The topic for the third class is defenses to criminal liability. Defenses to criminal liability. Now, as a way of introduction, it is not all that amount to a crime that may be punishable. Some acts may be excused for reasons that we want to discuss now. Apart from the fact that they may be excused, some offenses which are to have a more severe punishment may be reduced to a lesser punishment due to the fact or the content of our lesson this morning. And the reason for the provision of defenses to criminal liability are quite many, and the defenses that we are going to be looking at are also the reason for the introduction of why those offenses or those acts may not carry full punishment, or why some acts may be excused. For example, an individual may kill another when an accident occurs. And generally speaking, everyone will agree that when accidents occur, they are not usually planned for. And that is why the name accident is given, meaning that it was not planned for, it was not mapped out to be done in such a way, but circumstances are running beyond the individual through whose act the situation has occurred is such that the individual is unable to control. Take for example, you have been driving a car that has been functioning well for months, for years. Let's even say a brand new car. Everybody will expect that a brand new car will perform optimally because it's brand new, and every part thereof is expected to work perfectly without any form of error. Now, human beings are not perfect. So also are the engineers who produce or make these cars. So, and that's why we have what is generally called factory error. Are you following me, class? Even though at every stage of production, there is what we call quality control to ensure that what has been manufactured or what has been done are working properly. But of course, nature has a way of running its own show where human beings may not be able to cater for everything, and there may be errors. As a matter of fact, there may be errors that are genuine or mistakes that are genuine that are not acts that are considered to be deliberate. And then after the completion of the production, particular car is rolled out. You drive the car with confidence. Apart from those of us who may have brand new cars in this class, if any of us is driving and we notice that there is an issue that you are observing, we drive with care. If, for example, your tires are not good and you are driving to where you want to change the tire, you don't drive with all confidence. But for a man who is driving a brand new car, probably believe that there is nothing to worry about. Therefore, the word carry go will apply, and then it can be speedy within what is expected without any fear. But let's assume that in the course of that journey, an accident occur, or maybe there's a brake failure, so to speak. That action or situation was not in any way intended, but unfortunately, it has happened. So, what is it that can be done to remedy the situation? Let's assume that the same action had caused injury to someone. Let's say grievous bodily harm, to the extent that the party involved has a broken leg. Generally speaking, we will say that, was it done intentionally? The answer will be no. So if it wasn't done intentionally, there should be remedy for the man through whose action such a situation has occurred. We cannot deal with that man like the man who knew that his brake was faulty and he was driving at 150 per kilometer, or let's say he was doing 120, and is aware that his brake is not good. So it's more or less presumed that is reckless, or he had the intention to cause harm to people who may be on his way. Yes, ma'am.
What of if he doesn't know that his brake or anything in the car has been tampered with and he's driving as
Yes, of course he doesn't know. He's covered and protected in that he does not know. But you are aware that there is a difference. So what we are trying to say as a way of laying a foundation is that the law will not deal with someone who is careless and deliberate the same way it will deal with someone who is not aware that his action may cause some things. So that's why the law has created rule through which liability on the part of such individual can be reduced. Because even we that we are human will say, he didn't know. The law also is managed by human beings, people who have feelings, and then they adjudicate on matters before them based on how the matter is presented. And that's why if an alleged armed robber is brought to court, and then they ask him to go into the witness box, and he's doing like this, all of you that are looking at me now, you will say something is happening in your mind. What's happening in your mind? You say, is this one normal? Somebody that is the court and is still raising shoulder, doing as if he's the one controlling everybody. The judge will look at him and said, this one,
it's not so bad.
He's not sober, and he doesn't even know what he's in for. That has created an impression in the mind of the court to the extent that probably this one knew what he was doing. Therefore, he should suffer for it. It will be a different case if while they were carrying him, he folded his hand like this in a sober mood. He's now carrying the biggest of the Bible, like that's your brother that was alleged to have tampered with our finances, that took all our money to build estate for himself. He's alleged though. You're now carrying the biggest of the Bible and then be going. Something will tell you that this man is remorseful, that as a matter of fact, he has become a born again. Yes, that's the presumption, that now he has met Christ in prison and then is now a new man. And the Bible says that if any man be in Christ, is what? Is a new creature. So the court will begin to think that this man is a new creature. Let's treat him like that. Even though the court will not expressly treat him like that, but there is something in the mind of the judge, because the judge is human, will say, oh, this person is now sorry and sober for what he has done. And those are what we call extrajudicial factors that affect judgment that an individual gets. It's different from the kind of judgment that somebody who is arrogant, who does not even have respect for the court, who does not have respect despite what is alleged to have done. So, these are the reasons why, some of the reasons why we have defenses to criminal liability. So, having said that, we are going to take a look at the available defenses to criminal liability in our jurisprudence as a nation. And what we see, number one, is what is popularly known as honest claim of rights. We have accidents, mistake of facts. Another defense is extraordinary emergency. We also have the defense of insanity. We have the defense of intoxication. We have the defense of immaturity of age. We also have the defense of being a judicial officer. And also, we have the defense of justification, excuse, and compulsion. And there are still others that have been found in the law. Yes, please. Criminal code. Okay? And all these that we have mentioned are contained in the law. As we delve into the lecture, we see what we mean by them. Okay? So, let's start by looking at the first one, which is the honest claim of right, as provided for in section 23 of the criminal code. Now, the law is expressed here when it says that a person is not criminally responsible for an offense relating to property for an act done or omitted to be done by him with respect to any property in the exercise of an honest claim of rights and without the intention to defraud. Now, mere looking at the provision of this law, the law believes that When there is no intention to defraud, criminal liability may be what? May be uh, um, excused. Thank God we all have phones, and we are in class now. Some of us will put our phone by our side. The next neighbor will put his phone by the side. And let's say it was time for break. The simplest example, and you mistakenly pick another person's phone, your neighbor's phone, and you left yours, thinking it was yours. Number one, when we're talking about substantive offenses in our last class, we dealt with stealing. We talked about what constitutes stealing, what an individual will do that we amount to stealing. We took our time to look at what taking means as it relates to the subject matter of stealing. We also look at what conversion is as it relates to stealing. And one of the things that we saw as elements of stealing is the actual taking. When there is actual taking, that is, the individual has caused to move something that is the property of another person. You have moved it with, from the person without his consent. Okay, I show all this.
No, maybe.
Okay. So, the person has taken the stuff without the intention to rob the other person. Now, it will have been a different case if, when he was going, he picked his own and picked the other one. As a matter of fact, I was watching a clip, a CCTV footage of a man who was in a banking hall, and he was pretending as if he was making call, moved from the customers area and went to where a bank staff was, and he was holding a paper and placed the paper on the phone of the bank staff and removed the phone and immediately walked out of the bank. What I saw in that video is a case of the fact that human beings are usually very careless, except until something has happened that will now make us to be careful. Because I could see from the video that the man was making call, he was moving from one place to the other inside a banking hall. Generally speaking, I believe that people are usually restricted from making calls within the banking hall. And that's why some of us are going into the banking hall. We know that we cannot take calls there for security reasons. But this man held the phone and was talking, moving from one side of the hall, and then eventually sat close to a place that the customer should not sit. Nobody was able to ask him and say, Oga, please can you move the other way? To me, it was a clear case of carelessness on the part of the workers there. And I'm sure that usually we have security men that do patrol the banking hall. And this man cleverly walked, and picked the phone with his own in his ear, pretending to be making a call, and walked out of the banking hall. Now, from the picture I've painted, the man came with an intention to steal. So we could not have said that he thought that that phone was his own, because while he was making that call, he was looking left, right, and center. For those of us that have stolen before, you know what I'm talking about. Is there anybody here that has not stolen before? Only you. Ah, okay. Three of us. Okay, all of us here we have not stolen before. Okay, maybe you are talking about after another life. The only person that has not stolen in this class is me. So, if you want to do such a thing, the person is looking. That is an act to manifest that he was how to do what? To do something contrary to law. Man, that is your phone there. If you want to take that phone, you don't need to look at me. Why? Because it's yours. So that's one of the simplest way we can embrace this particular topic. Please, the person that is talking online, please mute your mic. I will walk away from the computer. You are disturbing me. So the law has said that a person is not criminally responsible for an offense relating to property for an act done or omitted to be done by him with respect to any property in exercise of an honest claim of right. So meaning that an individual may even be laying claim to something that is not his, thinking that what is his own. Now, when you look at, for those of us who sometimes we browse the internet, there's a prank that is more like prevalent now. If you put something here, maybe a drink, one of the prankers or whatever will hold a similar drink and pick the one that is coming will pick your own and walk away. As you go ahead to challenge the person, the other one will bring and put it there. And you say, what is my own now? And I say, okay, look at it. Is your own not there? And I say, don't be angry, please. I thought it was my own. This is what I was saying, you know what we were talking about. But do you know that ordinarily, the individual would not have approached that man if he was not suspecting that what was with him was his property. So that action is even what we saw that even kind of mild. Sometimes somebody will even go and hit the person. Why are you taking my stuff? Because he wants to defend his property and claim his property. Whereas what he is fighting for is not actually his own. The law can excuse such an individual, but the excuse is limited. So, but what we're saying here is that the subject matter must relate to property. So that brings us to the condition that must exist before an individual can claim this particular defense to a criminal liability. Number one is that the claim must relate to property. Okay? What is a property? We discuss that, or we define, I think it should be property when we're talking about stealing, that anything that is capable of being stolen, that's something that is movable, tangible stuff. So it must relate, this defense must relate to property. It will not relate to maybe maybe you are driving on the road and then You hit someone mistakenly. You now want to say it's my right of way. And at that point in time, I'm the one that is licensed to be on that route. It cannot avail you. But when it has to do with property, irrespective of what it is, no matter how small, provided it's a property of an individual, this defense will avail the individual. Number two is that it must be honest claim of rights. It must be what? Be honest. Yes, please go ahead.
You said that property is anything tangible
Yes.
and that can be
Yes.
movable,
Yes.
which can be stolen.
Yes.
Land is not movable.
Yes.
Can land be?
Land cannot be stolen, but it can be converted. Because of course, when we now start talking about property, we have different types of property: tangible, intangible, movable, immovable. For example, now if you have shares is a kind of property. Where is your shares?
My shares
Yes,
in the company.
that with the brokers. Have you seen them before?
No.
Can you see them?
Yes.
You know that intangible properties. But what we're saying is that property can be different type of whichever way. This claim only relates to property. It can now, depending on the situation, it can even become it can also be, it can also relate to even intangible. It's intangible, but the aspect of it that it cannot be taken is another issue, but it can be converted. Conversion is turning it to be your own, even though it's something that you cannot see. Okay, so the point is that intention must be honest, meaning that there is no intention to defraud, and that is the point, condition number 3. No intention to defraud. I gave an example, a very common example that can happen to anybody. You mistakenly pick another phone thinking it's yours, and you left yours there. Such an individual did not have intention to defraud. So the issue of having intention to defraud is also a paramount condition under this defense to criminal liability. Now, as a way of adding to the condition, the law provides condition number 4, that no right to the property need exist at the material time. Now, what does that mean? That no right to the property need exist at the material. I'm looking at the simplest way to explain this to you. Now, okay, there is a particular case I witnessed when I was in the university. A lecturer was teaching, and where he sat, he could see his car from a distance. And a student went there, opened the car, put the key into the ignition point, started the car, and started driving away. The lecturer could not continue his lecture, which I think none of us will continue that kind of lecture. Abi? Even sometimes as we are teaching like this, we can use style to go and check whether the car is still there. Abi? Not to talk of seeing someone driving the car away. That was why the lecturer started shouting, is that not my car? Is that not my car? If they had shot that person down in the attempt for him not to take that property. It will have been an attempt to claim what is yours, to prevent the man from taking your car away. But you know what happened? The boy thought it was his car. You know, some of these our keys can open another key, another car. You can try it one day. You can open another car, then the ignition can even start. The car can start.
The same model.
The same model. You know, the guys making these things cannot be as perfect as God. If they are as perfect as God, keys will not be opening the other one. So we give it to nature and human imperfection. But let's say that if the guy that drove off that car was actually driving his own car and the lecturer thought it was his car, and he had maybe done some harm to that man that was driving the car away. Now, what is key is that what was the intention? The intention was to stop a car that he presumed was his own. And under close examination, the car is the same, the color is the same, practically everything. Let's even say the wheel cover or the alloy wheel is the same. But he does not have right to that car that that man was driving. He only presumed that that car was his own. And that's why this provision, this condition is there. So the law is mindful of the human way of life. But of course, the law is made by man, right? So when you're making law, when laws are being made, is to manage or to take care of the needs of man in the society. So that is for the honest claim of rights. Now let's look at the defense of accidents as another defense to criminal liability. And this is covered by section 24 of the Criminal Code Act. Yes, please. Yeah.
Okay, the guy that took the car,
Yes.
thought was his
Yes.
assuming that the actual owner was thinking, I wanted to defend his property
Okay.
by killing the guy.
Yes.
So, what's the crime there? Is there any limitation or anything towards that action?
Yes, there is limit because he thought it was his own. If, let's say, for example, the guy who was driving the car off died in the attempt to claim the car, the position is that instead of that action to amount to murder, it can be converted to manslaughter. Manslaughter is a lesser offense to murder, but both of them, both acts must have resulted into death. But there is one that is not deliberate, and one has been established to be what? To be deliberate.
I want to understand this limitation.
Yes.
It does not necessarily mean that the offender will be totally excused by not.
Yes, it does that. It doesn't mean so. Yes, but in some cases, he may be excused.
Totally.
Yes. For example, somebody who is insane, if you are punishing him for an act he has done, does he know whether you are even punishing him? Or does he know what he has done? I don't know if you are getting the point. All right.
Like the case I mentioned about the cause of accident.
Yes.
Knowing that the car has been broken into and tampered with.
Yes.
And eventually somebody died.
Yes.
It's not actually claiming anything.
Yes.
What happened in that case? Does it fall under liability?
It will come under accident. But the fact that he doesn't know, we also limit whatever punishment that he should get. But he will still get punishment, especially if someone has died in the process. But usually there is a way that some form of settlement can be introduced in criminal situation. Like in Nigeria, what we see is that the family, the person who caused the action, they have a way of having a meeting with the family. And if the families are not ready to press charges, they may kind of forgive the man and ask the state to withdraw the action. And if the state does not withdraw the action, they may not go to testify to give evidence in court. And when there's no evidence, the case may be dead on arrival. So what they do basically in Nigeria for such things, I even heard of one recently. The man had to spend so much money to take care of the guy. Eventually, the person died. So I understand they do a form of compensation to the family and probably take care of the burial expenses, and then it will end there. Even the courts can when the state apply to withdraw such cases, the court may not object. It's a way of managing the society in such cases, especially when the act was not intended. We've already, yes, you want to ask a question?
I wanted to add, I had a similar case
Yes,
some years back. I'm familiar with Ogo.
yes,
My cousin's wife went to court as regular process.
yes,
She was going with her kids, three of her kids, one was a baby and the other one. So somebody assisted her in crossing the other
the
one.
younger
The
ones.
baby was with her.
Okay,
As soon as the other car stopped
yes,
for them to cross, it was a
yes,
zebra crossing. So as soon as once they helped her with cross, she was
yes,
about to cross. This tanker that carries sand, tipper
yes.
was just coming and just hit her and the baby. He didn't stop and they died instantly. Both the baby and her died instantly. He was even running. People had to chase and stop him. They arrested him and all that. Well, the lady and the baby died. They took them to the station. He was just bleeding and all that. But the person just said, "You should let him go." And bury the baby.
See, but ordinarily, if that man is to be prosecuted, he may not go scot-free.
Not really, not.
He may not. We can't draw we can't draw a total conclusion that he will be convicted, because number one, the duty to prove such offense is on the state. What if the state fail to prove properly? In that the man may say that where the accident happened, there was no zebra crossing there, even though there was. It's a form of defense that people can engage. I don't know if you get the point. But going by the fact that if it can be established that that place there was zebra crossing there and other vehicles had stopped. In fact, just like I said that there are some extrajudicial factors that can reduce criminal liability, there are other factors that can aggravate the punishment. They can ask him, did you not see other vehicle stop? Where were you running it to? Not like that. Yeah. Not like that. This thing, why are you running? Why are you running? They slap the man, slap the boy. Why are you running? Why are you running? The court too could give a stiffer punishment to that man because other cars were already there. It doesn't matter whether you have a brand new brake. There's a law requiring you to stop, especially if the light or the traffic light has given you sign to stop. So it will be deemed that the man intended the consequences of his action. That's the way the law will presume that he intended the consequences of his action. That was why when other cars were stopped, they were there waiting for the traffic light to ask them to move, he ran across the line. The law will presume that because every man is presumed to intend the consequences of his action. Yes, please.
In a case where there's no traffic light there,
yes,
and there's this zebra crossing,
yes,
and some people are already standing by the zebra crossing
yes,
to cross,
yes,
and the car is coming
yes,
without stopping and hits. So what will happen?
Well, I think in other normal circumstances, once you see people by the zebra crossing, you are bound to stop. It's only in Nigeria we don't obey all of that. You travel, you see what we're talking about. Even if it is one person that is by the zebra crossing, vehicles will stop. But here, we use our sense. We don't think that because even if you draw the zebra crossing and you paint it all the colors of this world, they know that we don't stop. We do, except maybe there is presence of LASMA or the police. That's when you will see us obeying. Many a times, even there are some areas you will get to. I was driving and passed somewhere around this university, and I stopped because the traffic light was as indicated that I should stop. And the people at the back, at my back, were shouting at me that why am I waiting? In one of the people keke that parked there, yeah, òṣìṣẹ́, ẹ máa lọ, that should go. Why? The traffic light is there for a purpose, but by our culture, we don't care. So when you get to that place now, the traffic light is always working, but people don't obey it. Maybe some of those things are peculiar with our own. Yeah.
By pedestrian bridge where people are meant to cross the bridge.
Yes.
And you see vehicles stopping for people underneath the pedestrian bridge to cross.
Yes.
I think that is not supposed to be.
Then again, haven't you seen cases where there is a pedestrian bridge, but people will not use the pedestrian bridge?
I'm saying underneath it, vehicles will be stopping for them.
Yes. So it is both with the drivers, those who ride vehicles, and normal citizens who also, let's say, how do you call it, pedestrians. It's with both of us. We are all very lawless. Maybe to say that, that's my own way that I can interpret it. But that's the society we find ourselves, and we are praying, instead of us to pray and work and change our attitude. So let's look at accident. A person is not criminally responsible for an act of omission which occurs independently of the exercise of his will, or for an event which occur by accident. As a matter of fact, we have talked about this over and over in the course of this class. What is an accident? An accident is something that occurs independently without the direct intention that what happens will happen. Let me put it that way. I have given several examples to illustrate what we are talking about. Now, under this defense, motive is irrelevant, and then no intention to cause the consequences of such act or omission. I did explain that you are aware that your brake is not good, and you are on your way to the mechanic. There is this normal expectation from you that you drive carefully. Anything less of that will make you liable because ordinarily, just like you're having a gun, a loaded gun in a crowded place, and you've done it to the point where all that is left is to just pull the trigger, then it will go off. The police or the armed forces that carry those weapons, they put it in different modes. It's only when it is needed that it will be activated. We have seen a situation where people died at event places due to accidental discharge. We've seen such cases. Now, should you have your weapon activated to the point that it can cause harm in such occasions? So sometimes these defenses are narrowly considered. So it's not like a general umbrella that will cover you, because we at every point in time look at the circumstances surrounding the case before any action or any decision can be made on the subject. Still on accident, we define an accident here as an event which is too remote and an indirect consequence of the accused unlawful act. One of the things you will see in this definition is that the unlawful act is still there, and that's why these defenses does not exculpate, does not set somebody free totally, but it can only reduce the punishment thereof, or whatever action or punishment or thing that the accused is bound to do. So an accident is not reasonably foreseeable as a likely probable consequence of such acts. Now, recently, a young boy was killed, I think in Ibadan, right? When the father was engaging in one-way driving, and then the story that came to light was to the effect that the officer opened fire on the vehicle with the intention to stop the vehicle. That's the story I heard. I don't know if mine is different from what you had. Now, what was expected, or what should he have done in that circumstance or circumstances where you have a place with crowded people, I mean a crowded environment, and then you shot? You claim that you aimed at the tire and you missed it, but the law want to ask, what can be, is there a possibility that you can miss the target in that crowded place, and then the bullet will miss the tire and hit someone? Those are the things the court will read into every situation. Now, the bullet could have hit anybody, not the boy that died. And that's the point. Whose life is more important than the other? No life is more important than the other. A baby born to down who already has life possesses the same right to life as a woman of 108 years old, because life is what? Is life. So the law want to examine that what could be the probable cause Just like throwing stone into the market. The stone is likely to hit someone. There's also a possibility that the stone may land on top of a shed that will probably not hit someone. But what is the probability that it will not cause harm? The probability, like you and I, who may be laymen and women in the area of that measuring probability, we say it will be a slim thing that the stone will not meet someone or will not cause harm to someone. The Yoruba people have even taken it further, that it will not just, the stone will not just eat just anybody. It will what? How did they say it? Can you help me? Okay, so even the law, even that adage or proverb was saying, even envisages that it's good, definitely going to hit a human being. That's why, because can a shed or an umbrella be your relative? So meaning that even the adage presume that it will definitely meet an individual. Why? Because it's a marketplace. So if that stone should hit an individual and probably break his skull, the law, even though if the individual claim accident, the law will impute it into the individual as having intended the consequences of his action. Because of what happened is a probable consequence of his action. You light a candle and you throw it to petrol that has poured on the ground in a filling station, and you are saying you are playing. You are not playing. Or you use the boot of a gun to hit someone on the head and you are saying you are playing. What if people say that they use that kind of thing play? So these defenses are there to identify with the individuals who may have committed such acts when there's no clear intention to do so. And there's nothing to read or to suggest that the individual was careless. So look at the part C. He said the accused must not have reasonably foreseen it as a probable consequence of his action. Let's look at the analogy I painted of throwing a stone in the market. Between the head and the leg, where is the stone likely to meet first? Why? Why the head? Okay. So, if the individual says that, I did not know that it will hit head though, is the leg that I thought. It's just like pouring water on the head and you say you are aiming at the leg. It will eventually get to the leg, but it will flow from the top down. So the accused must not have reasonably. So once you reasonably foresee, the reasonability here is that just like you have agreed with me that the head is likely to receive the anointing than the leg. The anointing that the stone carries, or let's say the pain that the stone carries. So there is reasonable foreseeability. So meaning that the defense of accident will not avail such individual if it is foreseeable that such action can cause that harm that has now occurred. Please go ahead.
So how do that case judge now? Knowing fully well that the person intention, rather than because there's an example that you gave when someone is not in sense
Yes.
that you think
Yeah.
so that person might be set you because even if you jail the person may not even know the actual thing that you do.
Yes.
This particular individual who wanted to end our trial and end up killing his mom.
Yes.
We will say that this person is in his right sense.
You may help me to who can help me to provide an answer? Who can provide an answer for me?
So I wouldn't say it is right sense because one in that case was actually referring to a mad person, someone that is insane.
Yeah.
A mad person comes into the market, throws his phone,
Yeah. Where? But someone who is an officer of the law, and then he has been handed over, he's been given that particular weapon. There is this presumed sanity attached to the individual. So he won't take, he's not going to be taken as like someone who is insane.
Not actually insane, but they might not be right. He's not in his right because he cannot.
Then the person who gave him the gun will need to also answer for it. How can you give a gun? So you intended whatever that individual will do. That is no. This thing we are saying, it may appear technical, but we need to apply what we can see. It will be a different thing if the man was drunk. If the man was drunk, again, doesn't take away that liability from him because you are on duty. And then do you know that what you are taking can cause you to temporarily lose your senses? You've just made money and said, bring the beer, bring it. And you put 5 here. And you say, serve all of you, you serve all of you. And then they are hailing him. Thank you, sir. Officer, the boss. And then you know that the havoc that size of 5 bottles can cause. 25 bottles of water cannot cause it. So there is going to be like a presumption of you intending the consequences of your action. Now, I have a query for you. I need you to read it. And then let's apply what we have discussed so far to it. So just read it. Or I'll read it out for the benefit of those who are online. M strikes a blow. A collapsed and died because of inherent disability. Is this an accident? Will the answer be the same if M strikes A and A collapsed and fell on a sharp object and died? I want answers, please. M strikes A blow. A collapsed and died because of inherent disabilities. Is this an accident? Will the answer be the same if M strikes A and A collapsed and fell on a sharp object and died? Do you want to talk to ChatGPT? Some of you are holding your phone. Are you talking to ChatGPT already? Okay. Sir, can you help me? Okay.
If M strikes A,
Yes. Yes. Okay.
But if it is an accident, because this person asked, is this an accident?
Yes.
And I want to put it that if it is an accident,
Okay.
A might not be. There is no way that A will not be punished.
No, that M.
I'm sorry. There is no way.
Yes.
M will not be punished for the action, but the punishment might be minimal.
Okay. Are you saying it's an accident?
Even if it is a life has been lost.
Okay.
Since a life is lost,
yes,
due to the action of M.
Okay. But to you, sir, is it an accident?
The intention will prove it is an accident.
So let's say, okay, we cannot even know what is in his mind.
Yes.
Yes. Thank you, sir.
The intention is actually to inflict pain,
Okay.
not kill.
Okay, you were with them, Abby?
Yes.
You were with them when it happened.
No, fighting. Like
Yeah.
I saw one recently, secondary school kids fighting.
Yeah.
And in the course of the fighting, he just held the boy and hit him on the ground.
Yeah.
And the guy was just shaking and I think he died or something.
Okay.
So in that scenario, it's not as if he wanted, they were both fighting.
Okay.
So it was not as if he wanted to kill him.
She does not agree with you.
So
she's saying no. Let's hear her view. Yes.
For me, a blow can land anywhere.
Okay.
It can land on the head, it can land on the chest.
Okay.
And you don't know the health condition of that person.
Okay.
So you will be held responsible.
Okay.
It cannot be an accident because it's a fight. A fight is not an accident, it's a flat thing.
Okay.
A fight is a reflection of action.
Considering what she said, that it's to inflict pain, will your answer still remain the same?
Yes, pain can cause death.
Okay, that's beautiful. Yes. So it is not an accident.
No, it's not an accident.
So your answer will be different if the intention is to kill him. If it can be established that the intention is to kill him, will it still be an accident? Okay. Now, look at the inherent disabilities there. There are different types of slap, right? Has anybody received slap here before? No, anybody here? Because I want somebody that can give me. You have?
Very young.
Okay.
You know this thing they call small stars?
Yes.
You know when they slap you?
Yes.
You'll be seeing your eyes, you'll be blind for like a minute or
oh, okay.
something like that.
Okay. Any other person? You, sir. What did you see when you got the slap? Okay. There is a saying that if army slap you, you will know that police is your friend.
Yes.
Because that means the kind of a slap that an army will give you will not be the same with what a police officer, who is still considered to be a more humane, friendly officer than an army. Now, can a slap kill?
Yes.
It can kill.
Yes.
If I say, but that's not the intention. If the person is not that way,
Yes.
if the person is not that, and he's not expecting that,
Yes.
and keep short person, the shock can put the person.
Okay.
How will you know that the person is not?
Okay.
You don't know.
It won't be the slap now. That's the shock that gives. But the slap is just the one that
You see, just the way we couldn't arrive at a single answer is what we cannot arrive at a single answer here. But the thing is that the query is agitating your mind to know how to apply the rules. Now, the law does not care whether your victim was going to die the next minute, but that when you slapped him, it let that 1 minute now came and the person died. The law does not want to know that. You know, there are some people that they are village people that are following them everywhere they go. So that person will have ordinarily died at that time. But because the village people of the one who attacked him is following, they are following him. They assisted him to that place of doom. So, in law, the inherent disability may not be a defense because the law presumes that you will take your victim the way you meet him. Irrespective of what is inside the person, you will take it like that. And I think that has to do with what we call eggshell principle. You know, egg. Egg is very what? Fragile, right? But there's a way I will give you egg now to break. You cannot break it. Right? But this your two palm may not be able to break one egg. But this palm, this your finger, can break egg. How?
It's possible now.
If you put an egg here now and you strike it like this, it will break now. But if you hold the egg, the two edges, you put them here, you press it like this, it will never break. Go and try it at home. Next class you tell me. If you put it in the other direction, it will break. If you hold it like this, it will break. But if you put this, what I'm saying is that two hands may not be able to break it, but one finger may break it. So the eggshell is a fragile stuff. You know that it's fragile. It will also be imputed that your victim at that time is fragile. Now, the second part says, will the answer be the same if M strikes A and A collapsed and fell on a sharp object and died? That's an accident. Okay? I think I want to agree with you there. So, let's move on. A, B, and C are together. D, the wife of A, is hurt by him, and in the fit of rage, A's wife attempted pouring hot water on A, but the water splashed on B and C. Did that be an accident?
Yes, it's an accident.
It was not intended for them. Okay. Then A and B are married. One night, a quarrel ensued between them. B, the wife, left the room to be with their newborn baby. Apparently furious that the wife ignored him, he took a belt to beat the wife, but the belt missed and hit the baby on the head and killed the child.
It's not an accident. It's not an accident.
The women are the ones saying it's not an accident.
Yes.
Women, calm down, calm down, calm down. You will notice that it was the women that said it was not an accident. We know why, Abi. But the question is that what was the intention? The law will not include emotion. And these are the things that now fortify the defenses we are trying to establish. It is only a mad man who will intend that the child should die. So, yes, but emotion will come in, but the court does not work by emotion. Sir? Which one? The A, B, and C? Where it can mean it's an accident. Because number one, the lady did not intend it. But again, just like I said earlier, you throw a stone into the market, it's definitely going to meet someone. So it depends on how close the guys were. If it was maybe when the woman wanted to go and pour the water, the other person maybe ran away, and then that mistakenly, the circumstances we explain. By the time we are talking about type of judicial evidence, we will talk about circumstantial evidence. It will show us that basically some of the things surrounding the happenings will probably determine the outcome of an issue. Okay, so let's look at another defense: mistake of fact. Mistake of fact. A person who omits to do an act under an honest and reasonable but mistaken belief in the existence of any state of things is not criminally responsible for the act of omission to any greater extent than if the real state of things had been such as he believed. Mistake of fact. You think that it is this, but you did this. The law says such an individual is not going to be liable for it. But let me ask you a question. Two people, man and woman, not married, they are together as friends. And then the lady has said that I'm pregnant. And then the man procured a situation where the lady became unconscious and made the doctor to carry out an evacuation. And after the evacuation was done, the process was done, it was discovered that the lady was not even pregnant. And in that country, abortion is a crime. With mistake of facts, have they that individual? There's what? There's an intention to commit abortion. So the issue is not whether there was baby or what the features or not. I agree with you. Yes. 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 Okay.
That's not a mistake of fact. He actually saw it.
Yes.
But he eventually turned out to be the wife of the king.
But in that case, if he actually saw an antelope and after killing, it now becomes something else. That may not be ordinary. And the Lord does not believe in juju. The Lord does not believe in. It will be difficult to prove that. Is the king likely to agree that the hunter saw an antelope? Who is the victim now? There is freedom of movement, my brother. You can choose, as we are here now, you can choose to go and build in the Sambisa. My sister, you are in the spirit. You have as a citizen of this country. Yeah, you are free. Yes, sir. Let's take care. Yes. Go ahead, sir.
I just want clarification regarding the last scenario.
Okay. Okay.
So you concluded by saying that you are.
Yes.
But then I understand that there are two elements.
Okay. Okay.
Intention and action.
Okay.
So you see there was a sense of what
that action is the actual abortion process. That's the action. The intention is making it to happen. The two are already present.
When you said that the person was not pregnant.
Was that pregnant? Yes.
So that means there was no abortion.
But the procedure has been done. Okay. Okay.
First of all, I think a test should be carried out to ascertain the
It's not in all cases. Because if you listen to the scenario properly, I started by saying they were not married. There is a possibility that the guy just did not want a child and did not want to go and do any test and just holding on to the claim by the woman.
Yes. So my own question.
Yes.
I'm not even talking about test.
Okay.
Without test.
The fact that there was no baby there.
That when you got there was no baby.
Yes.
So there would not have been anything to abort the person. Exactly. So at best, that person would have been charged with an attempt to abort. As against
Well, let me also still agree with you, because again the circumstances may also determine the outcome. Because in the case of evacuation, it is only when, maybe especially if scan was not done, it is only when they are bringing out whatever is there and anything could come out. What if a part of the woman's body was being taken out? And they also believe they actually evacuated the baby. But meanwhile, the person who claimed that was pregnant was never pregnant. So the circumstances or the details of each of those transactions will explain liability. But of course, the fact that you even did it, and I said again that in that country that abortion is a crime. So just like setting out to go and commit robbery and you committed murder there, whether it's murder or robbery, you have committed offense, even though that was not your intention. So that's where all of those things play out. Now the condition to this, you're talking about mistake of fact. It must be a mistake of fact, but not the law. An accused pleaded mistake that he did not know that it is against the law to pay bribe. Ignorance of the law is not an excuse. So the mistake must relate to facts. Do you know that it's possible that you don't know that giving and receiving bribe is a crime? In our own crime, we don't call it bribe. We call it different names. Give me the names. Appreciation, yes. Tips, donation, yes. You know you have done it before. You are able to give me more. I need more names. That man has assisted before, and that is it. You see officer on the road, you don't have a driver's license, you don't have or you have something that will implicate you, and you get there, say officer for water, and you go. So here the courts did not agree with this man, because whether he's aware or not, once it relates to law, the ignorance of the law is not an excuse. Number two condition is that it must be an honest and reasonable mistake. You're welcome. Honest and reasonableness is the fact here. Look at the scenario. He believe X, his mother, is the witch behind his woes in life. He killed her. Is this a mistake? Is it honest? Is it reasonable? For it to amount to reasonable mistake, it must both be honest and reasonable. Now, what do you have to say, class? Can a mother be responsible for a child for her son's woes? Really? Really?
Yes.
You are very sure, madam?
Yes. Very, very sure.
In this country. Now, wow. I'm hearing this for the first time. Oh. So, is he honest? But again, even if the woman was the one responsible, can you take laws into your hands? Okay, so this must be honest and then must be reasonable. Where both are lacking, there's going to be an issue. Yes, please. Yes. What they have told me about her is truth, is honest. Hey, but how do you confirm that? There are false prophets, false imam, false people everywhere. Okay. What is the basis of the work of prophet is not honest? Okay. And to me also, okay. Let's take it from the point, this point. Mistake or fact. Just a minute. I'm trying to get your friend. Both of you were outside, and then before you went out, 3 of you were seated in that place, and you left your phones there. So one went to the restroom, the 2 of you were outside, and you were coming in, and he said, "Please help me take my phone." And when you entered, you took the phone of the other man that went to the restroom. Is it a mistake? It's a mistake. How do you establish that it's a mistake? You pick a phone. Is he honest? Is your action, can it be said? Why? How do you establish that? The fact that what's on the table Yeah. One. You picked one. All right. And that's how it is determined. The circumstances of it will also show. Saying that, oh, I parked the car outside and gave him the key. And he went there, he thought this was the car. Put the key to the door, it opened, and drove another person's car away. These are possibilities. And he left the one that it actually is. Like we established earlier, those keys can sometimes open one another, other cars. So now let's look at this. Liability exists but not greater than if the state of things had been the way he or she perceived it. You see, these defenses we are talking about, like we said ab initio, it does not exonerate in all cases, but rather it may reduce the what? The punishment. Now look at this. A intends to burgle B's house, but burgles C. Can plea for mistake avail him? Answer now. Will mistake avail him? Why? Because there is a burgle. All right. So the law can, however, exclude mistake. X had a noise in the bathroom, thought it was a thief, and fired a gun 7 times, resulting in the death of his girlfriend who was washing in the bathroom. Can a plea of mistake avail him? The person that did something similar. Who? Yes. So because he's in jail now, what will you say? It was not a mistake. Okay, now because it's already, if he was a free man, your answer would be different. Yes. What makes a lawyer a good lawyer? Okay, now look at it from the eye of people in the class. Can it be a mistake?
It's not a mistake.
Why?
It's a noise, and he should have also verified before firing a gun. Even if, yes, hold on, I'm coming. 7 times. You would have been just once to scare the person or the thing away. Do you understand? But firing 7 times, so he's targeted to the person.
But I tell you now, and I lie not. If someone should push that door now, and enter, you'll probably be under that place. You'll fly away. So you will not have time to verify. Okay, yes, let's hear you.
Like it's the noise that you heard.
Yeah.
Just noise.
Yeah.
And like what she said, not just fire 7 times.
Okay.
Just to fire once or something. And you're not even supposed to fire in the first place. Why will you fire hearing the noise? You should look at the whole fire. And you knew quite well was not fully.
Is that what? Okay, yes, ma'am.
I'll read the scenario.
Okay.
You're at home. You forgot to lock your door. Someone just opened your door and entered into your house and you're in the bathroom.
Yeah.
You will run outside.
Okay.
Right? Let's say you don't have any ammunition. You run outside with fear.
Yeah.
Like, who is in my house? Who is inside my house? Who are you? Let's say it's at night and there is no light. If you have anything within you, you can use it as self-defense. Right? So let's apply that scenario to this case that we're talking about now. You're in the bathroom. It might be like maybe the person forgot to lock the door, or the reputation of the person. Maybe all the security guards have been killed, or given there's a way you can kill somebody who carries into a car, strangle, and the next person is the owner of the house. So the person, to me, has the right to
to fire the gun 7 times. Yes, from that scenario. Yes, sir. Let's hear you.
Sorry, sir. In his own case,
Yeah.
let us have it in mind that that guy is an handicap.
Yes,
Yes, he is an handicap. So there was no way for him, if the person gets close to him, to defend himself or to escape. And fear can make one do anything. Only that trigger that made 7 rounds to come out might not be in his right mind. So what put him in the jail in that scenario, sir, was the problem between him and his girlfriend.
So there was more like there is it's presumed that
Yes.
Now let me pick some of the things you said. They are all quite valid, but I have issues with some of them. When someone is being inflicted with fear based on whatever, he is not in his right senses. Yes. But in the middle of the fear, especially when there is no harm, when you have not discovered that there is no harm, the man may reboot, let me use that word, and come to his senses. Now, where I have issues is this. The gun went out 7 times. And that confirms what you were saying, that there's an established case of in whatever thing between them. If you are in a relationship with one person, all of us that are here now, if your husband should shout in that corridor, it's one person that will say, that's my husband. It's one person in this room that will say, that's my wife. Why? Because you know the voice. So that's one of the reasons why the guy did not. He said, how can you be in a relation with somebody and there's nobody in this room? Eh? No, what I'm saying, they say there's nobody in this room who will be hit by a gun and I will not see anything. Shout to the one that has not died. Say we say I've what you call Abi. So when there is something like Motikuo, is it not sufficient for him to know the voice of the woman? So that's why I said the circumstances of every case. I'm looking whether it's my car that is being you know, you said it before. Maybe somebody is mistake of honest mistake. Yeah. My very close friend that our car was stolen. Very, very painful thing. So the guy, you said something about this neighborness, and that's why I said even though fear came upon him, the noise of the lady should have made a statement, and that was why it was difficult for him to escape, all of that. I think it was at the time giving some form of it was released at the time. I didn't follow up again. Like the family of the lady were not okay with the sentence. We have automatically turned out Stapitorius case into what we have here. But that's not exactly but that was what informed this scenario. Now, mistake does not remove responsibility, but limit it to the extent of the belief. Sure. Do you understand? Mistake does not remove responsibility, but it can reduce whatever punishment that is to be given. if Oscar had shot words and that lady died, there would have been a way out for him. But of course, the circumstances was enough to prove otherwise, to establish that there was that intention.
And they did not establish the kind of noise. Whether she was singing or was she making the kind of noise that can scare the guy away from the house.
Anything can actually scare people. You know, we have different degree of somebody now, if something drop there at the back, somebody that is here can jump up. Meanwhile, somebody that is sitting where a guy is seated now, just turn. But somebody say, we'll jump. So everybody will have different degree of being able to absorb. Now, the next defense is extraordinary emergency. Subject to the provision of the criminal code relating to acts done upon compulsion or provocation or in self-defense, a person is not criminally responsible for an act done or omitted or omission made under such circumstances of a sudden or extraordinary emergency that an ordinary person possessing ordinary power or self-control could not reasonably be expected to act otherwise. God forbid, if you hear gunshot, sporadic gunshot there, this place will contain 5 people. And you start hearing different type of tongues, different prayer. The one that has not called the mother in the last 5 years will remember the name of the mother. It can make you to cause to commit a crime or to do something. Now, we'll explain further. Can you move forward? No. Next. Now, it must be certain. These are conditions attached to it. An ordinary person possessing ordinary power of self-control could not reasonably be expected to act otherwise. E.g., swerving off the road suddenly to avoid hitting a child and end up injuring several people. You know, it was not something that was planned for. Okay? And the decision that was taken was also taken in good faith. But unfortunately, other acts or mission had also followed. Yes. Presumption, no. Can you just add them? Let's. So all these defenses are being deployed every day, but usually people use them even when that particular thing was not what they intended. Because nobody really wants to have maybe experience any form of pain, even when they have done something wrong. They tell you provocation, tell you this and that, and all of that. So let's move on. We look at presumption of sanity, section 27. Onus is on a defender pleading insanity to produce credible evidence of insanity. Okay? Insanity, of course, is when someone is not in his what right senses, and then okay for whatever reason. So a defense of insanity could know that the defendant committed the offense, but there was no intention of menstrual on his part. Just like a mad person who is walking on the street decide to um to set fire on a car. The probability for everyone to adjudge him as not knowing what he's doing is very high, and then it will be difficult to impute guilt into him. So consequences of a successful plea of insanity is verdict of not guilty by reason of insanity. Now, the case of Aro and Ashifuwo, he was alleged to have committed murder because he stabbed someone 3 times, which led to the death of the person. The trial court where he was tried convicted him because, number one, the number of times which the stab took place, but whether or not it was done in self-defense is another thing altogether. But the court found him guilty for that offense, even though they were able to plead defense of insanity. But on appeal, the West African Court of Appeal, after reviewing the evidence, saw that it is not only by medical report that you know that somebody is insane. Somebody can be well dressed, okay, in the face of it, and the person is insane. Evidence of irrational behavior at intervals suffices. But the question is whether at the time the offense was committed, the person was in his right senses. But that will be difficult for the prosecution to prove. So the favor lies more in on the part of the accused person, especially if his case is well known within the environment that he can display evidence of insanity at different occasions. And that was why the court, instead of upholding the judgment of murder, the West African Court of Appeal reduced his punishment, leading to manslaughter. Because apart from medical evidence, it was established that the individual is suffering from insanity. But the question is, can someone who is insane commit crime? Class. Can somebody who is insane commit crime? Who said no and who said yes? You said yes. You said no. Why the no?
Because, like I said earlier,
Yeah. Yes. Okay.
And the same person can commit crime.
Okay. Yeah.
And if you are insane, of course, you are acting not intentional.
Okay.
But then, have a question.
Yes, please.
Concerning this West Africa,
Yes.
so if I understand what you said very well,
Yes. Yes.
The judges still believe that the man is not insane, or I just need to agree.
Yes. I said that outside medical reports, evidence of irrational behavior that that have been tendered or presented to court is sufficient to even override that medical report. Because what if at the time the man was examined, he was in his lucid period? He was okay. And then I do not know, I'm not a medical doctor, whether insanity can be detected in the blood. So I'm sure also, I may be wrong, that some of the things that form the decision of a medical personnel that can make him to adjudge an individual insane, it may also be a person's behavior and character. So now that was what the West Africa Court of Appeal relied on, because of course there were series of evidence to prove, and you know, sir, that the onus of proof is not on him. Yeah, but his defense is likely to have a defense, because it's possible for him to have people who have witnessed his irrational behavior at several times come to give evidence on his behalf. And that was why he was not exonerated. The charge of murder will be, conviction of murder was reduced to manslaughter. Yes.
The evidence or the charges,
Yes.
was it based on, because you mentioned that you guys have a
Yes.
and also you mentioned defense.
Yes.
So is it based that he was defending himself by stabbing the person? Is that why he was charged?
Well, the fact of the case did not state self-defense. And at the end of today's lecture, you will understand what self-defense really means. That self-defense that you probably know is quite different from the actual defense, and it's usually a very narrow thing, difficult to prove, but we'll see. But of course, okay, that I don't want to talk about self-defense now, because it's part of what we're going to talk about. But the point remains that other evidences must have been adduced before court, which the trial court believed was not sufficient to exculpate the man, and he was found culpable. While on appeal, when you have done a case at the trial court, what the reasons the court gave not to have fined for you, not to have given you judgment, is what you strengthen on appeal. So I believe they sought out for critical evidence to show that this man know well, and then probably they've shown cases where the man even destroyed his own car, where he destroyed his own car, the car that he bought with his money, or the security house of the house he built, set it on fire, or situation where there's a video of him that left his bedroom, went to the center of the road, and said that's where he wants to sleep today because the AC is blowing him directly from there. Those are sufficient proof to establish for someone, not that he doesn't have a house, there is AC in his, and he said it's the AC that God has turned on that he wants to enjoy at the center of the road. So those are likelihood of what led to the reduction of the punishment. Okay, any other question?
I'm trying to apply it in that situation now. Simply saying that I'm a same person cannot commit crime. But in this case, it was one of them was redeemed. Now, because that implies that even a same person is very clear to dealing with the same person. But such an same person cannot be said to have committed crime if any crime was actually before the same person. This is what I mean. There was a lady
Yeah.
one saw, and the same lady was very popular in the town. The same.
Okay.
Because I saw moving to the border of that little girl that something to eat.
Okay.
Yeah. But the lady, that little girl just came out from the shop and said, my mom is not around. Go away, my mom is not around. And the next thing was the aggression. You see the aggression in her. She approached the little girl, tried to grab her, but thank God the lady, the little girl was a bit faster.
Okay.
Despite that, she fell down and she almost hit her head with the wall.
Okay.
The lady escaped. I was not imagining. Assuming the lady, the same person eventually grabbed her.
Yeah.
And something, necessarily happened.
Yeah.
That simply means the lady and the parent will sober because nothing will be done to the same person.
Yeah, I agree with you, but you see, well, if we talk about what we want to talk about now, which has further explained issue of insanity and unsoundness of mind, it is very difficult to place guilt into such an individual because, like we say in Yoruba, orí ẹ̀ ò pé, meaning it's not complete, not whole. The way Yoruba express it, meaning something is missing. So when something is missing, the whole thing cannot align properly. Okay. So he said this disability under section 51 of penal code is unsoundness of mind, producing incapacity to know the nature of the act or that the act is either wrong or contrary to law. The disability and the existing condition must both have occurred at the time the offence was committed for the plea of insanity under both codes to apply. Do we understand now? Now, the question is, as at the time the person was doing it, was he or did he can we say that he understood what he was doing, or that what he was doing was contrary to law? Both of them must be something that can be must, we can say, that existed at that point in time. Otherwise, he will not be able to engage this defense. But if it's shown that he understands the nature of his acts, but he does not know that it's an offense under the law, it's a different thing. Because we've said in this class that ignorance of the law is what? It's not an excuse. So the fact that he knew what he was doing, but only that he didn't know whether it will amount to an offense, will not in any way avail him of criminal culpability. So therefore, the disability under the first paragraph in section 28 of the criminal code is a state of mental disease or natural mental infirmity. It's different from a self-imposed insanity, which we can, in our own way, introduce as intoxication. You get yourself drunk because you want to achieve a goal. The law will not fine for you. So the position remains that the disability must have produced loss of capacity of the offender to understand what he is doing. Apart from that, he cannot control his actions or to know that he ought not to do the act or make the omission. I gave you the example I gave regarding Oshu Fiso and the states. I said, what if at a certain time the man had set his own car on fire? That can only be done by somebody who is not in his right senses, except if it's a if that is a ritual for him to sustain his wealth. Except that every 3 months you must sacrifice your best car, set it ablaze, then it will come. Another one, bigger one will come. It is only on that we can say that yes, it's normal. But for a normal situation where probably before you bought the car, you've collected the ajo cooperative. Apart from the cooperative, your uncle still added money to it, and then person now just wake up. Even the cooperative money has not finished paying. Now went to go and set the car on fire. Except maybe the village people are at work. So the defense of insanity demonstrates one of the hallmark of excusatory defenses. The existence of a disability causing an existing condition which makes the defendant not a fully free and responsible agent. So this part, all the ones that we have talked about, even though they provide excuses for the individuals, they reduce the extent of culpability to a level, but not completely excusing the individual. Unlike in this case of insanity, because like I said before, what will you be punishing the individual for? Does he know what you are punishing him for? And even when he's being punished, does he know whether he's being punished or not? So these are the conditions or situations that play out. Now let's take it further by looking at the defense of intoxication. Defense of intoxication. According to Black's Law Dictionary, intoxication refers to a diminished ability to act with full mental and physical capacities because of alcohol or drug consumption. The inability or diminished ability to act with full mental capacity. But under our laws, the general rule is that intoxication is not a defense to criminal charge. Why do you think so? Why do you think that our jurisprudence does not embrace intoxication as a defense to criminal liability? I have the intention. Okay? Yes? Is self-imposed. So the general rule is reasonable to the extent that a person who knows that his mental and physical capability are likely to be reduced because of an intoxicant cannot be allowed to seek excuse based on his willful act of consumption or using it. I think the law is fair enough, because if not so, anybody can then have a willful act with the intention of escaping liability because of that. The Nigerian law draws a distinction between the effect of voluntariness and involuntary intoxication. Is it possible that somebody can be made drunk?
Yes.
So it's a different case from the voluntary aspect. This is involuntary and one is voluntary. So these terms are not used in the criminal or penal code, and they are merely used to categorize the possible effect of intoxication in certain contexts. Those who get themselves so high because they want to achieve a purpose should not be allowed to go free, because what they did was a deliberate act at that.
What happened when it's an involuntary?
Involuntary. Yeah, the defense will avail the individual, because that means he would not have done the act ordinarily if he was not under intoxication. So the intent cannot be there. This is like a case of force intention, because he did it. It's presumed he did it, but it was induced by intoxicant. Yes, section 30 of criminal code, immature age. A person under the age of 7 years is not criminally responsible for any act or omission. Why is it so? What? Yes. Okay. But will your answer still remain the same if you look at the Nigeria of today, all the times that we are in? What are the things that you have seen 7-year-old? What have you seen them do recently that is beyond the normal? Anybody? Okay, let me say that. You said what?
They smoke weed, they are into prostitution.
Okay, at 7?
Yeah,
So some of those things that you don't know, some people have come across them. So I may not, I am not in the position to even disagree with you, because to me, I also think it's a possibility. I saw, yes, you want to say something? Yeah.
whenever the mother leaves the house,
Yeah.
two boys, 2 girls.
Okay.
So when she leaves the house, because she is going to keep watching certain acts, TV,
Yes.
where they are kissing, taking with each other, so the picture has been stuck in the mind of the children.
Yes.
So whenever their mother leaves the house and goes to work, they will lock the door and lock it.
Yeah.
They'll close the windows and they will share each other.
Okay.
The firstborn takes the first, the third born to the girl. The second born, which is the girl, takes the fourth born, which is the last boy.
Yeah.
And the last boy is age 7. So the last born sleeps with himself.
Yes.
The other brother sleeps with his younger sister. Today, tomorrow they change the name. So it's been going on for months.
Yeah.
Until the neighbor heard the sound and alerted the mother.
Okay.
When the mother didn't beat the children, she just wanted to say children. So that's why I say that what she says, you are saying it. So it's not something.
Okay. Now that's an angle to it. Another angle is that can a 7-year-old achieve penetration, maybe if we are to put up a case of rape, you doubt. It is very difficult to conclude because of some of them have very big stature from so 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 let us leave it afloat and align with what the law says, that a person under the age of 7 is not criminally responsible for any act or omission. Yes.
A child that stays with one of my bosses is more like a maid actually, but she doesn't take her as well. She takes
Yeah.
her to school and all that. An incident happened when she noticed that whenever the child wants to serve her food, she noticed that the plate is not well washed. You still see traces of the soap
Yeah.
before she puts the
Food.
food inside. So something now happened and they had to call her. She now said that okay, she had a friend in school that she was advising that when she's being maltreated, that she should just all she needs to do is just put all this insecticide in your tea. She's doing it bit by bit. And eventually one of the persons that stayed with died. And they were now asking her that if it's the case of putting the insecticide actually killed the person, they were like, no, that the person had a natural death, but they have been doing that. And their kids in primary school.
Well, it's like they say that a lot of things are happening. Okay, now let's go on. A person under the age of 12 is not criminally responsible for an act or omission unless it is proved that at the time of doing the act or making the omission, he had capacity to know that he ought not to do the act or make the omission. A male person under the age of 12 years is presumed to be incapable of having carnal knowledge. Yes. It's not now. Yeah. Yeah. Okay.
So whenever I'm not at home, my husband is not at home.
Yeah.
She has sexual urge towards my son. So when I'm not at home, she goes and starts touching my first son. His manhood. She tell me, can you still at home when she has question?
Yeah.
And my son is just 3 years, doesn't know anything. 3 years, sleeping, and she's fine.
Yeah.
Because you know, she can't go lying on her lap, that's cuddling. The day, one of the days I go to the school, I was inside the room. I love myself.
Yeah.
I love myself. And I said, Holy Spirit just kind of put the value. I stood up, opened the door, two things that will never even take her something was inside. And I saw her, she raised her clothes up, opened her button.
Yeah.
She wasn't on grass. She dragged her skirt up. I called my son to come and see. So immediately I got to the phone, I was mad. And then I counted on her to do something. You want to use your my kid at the end of the day.
How old is the person?
16,
Ah.
16 and September 16.
That one is more of an adult.
And my son is just 3 years old. And yesterday I was interrogating her psychologically. I was asking her, you know, I said, tell me this, I don't do this, I don't know about it.
Yeah.
That's what she started complaining. But before then, yesterday I was led by the Spirit to search her school bag because I think it's
Okay.
very good school. And I opened the school bag. I saw earring. I saw jewelry. She took my earring, my necklace. She took everything. She took it at the bus.
In our bag.
Yeah. And when she goes to school,
Yeah.
she had a friend that gave her a ring and another jewelry. She didn't tell me. So I was going to search her bag yesterday. Then she now started complaining that whenever you break time, she has this friend that goes to
That will stay behind the car, and then she will put on the ring, put on the wig, and put something else.
Oh.
When I was talking to that, I you tell me about this problem. How do you feel when I'm not at home when you are having my
Hmm.
She said, whenever she did it myself, she would be having the words, she wants to sleep with me.
Hmm.
She wants to sleep with me, she wants to touch me, not like the way she and her brother.
So, meaning that if you trace the egg downward, it may fall within what we are talking about.
So I don't understand. But you have to tell me how is it going to say the dad is currently with you. Why? Because the dad is with 6 years old and 5 years old girl. So he doesn't come with you. I said, now I see where this is coming from. I said, so how does the ball used to come to you? So whenever she's washing with bubble, she will be touching me every. And then I said to myself, there are some mistakes we make when we go to play people. We need to
Yeah.
find out about their background.
Yeah. Even allowing them to stay. Hmm. All right. So but the law, except in your case now, you probably have evidence to show to yeah. Which can, so it's difficult to deny. But in the mere sense of it, the law believes that at that age, such a child is not able to do all of that. But like we said, these days you can see a child of 12 that's already looking like someone who is in the university already. And then, of course, is he a child, one house please, is he a child who maybe when she was in primary school, she's been made to be dressing indecently, that will wait till 12 before she will become wild, or he will become wild? It doesn't happen like so. In the real sense of it, in normal situation, it may not be a possibility, but from experiences that people have shared, it is a possibility. But we will stick with the law.
So this session that talks about the
Yes.
still maintaining this section for because of the time we are in now.
It's still active. Yes, sir. Go ahead.
Is it only that session that people to have knowledge? Because I have a mistake, I think it was very bad. A boy of less than 12 was that's going to school.
Yes. Yeah.
That boy, as he committed the crime, or because it's 12,
Well, the issue of culpability when it comes to children may also be examined based on the acts that they are into. Now, look at this section now. It said, unless it is proved that at the time of doing the act or omission, he had capacity to know. Someone who know, if they bring, maybe the number of us in this class now were about 30. They bring 30 rifles. 25 may be useless. Why it is only 5 that may be useful? Because the 25 of us may not know how to handle it. Right? Why it is just 5 people here who will be able to use it. So the question is, for the child to have the capacity to use it, it's already an established fact. So that is why for every law, every rule, there is an exception. They can bring a boy of 16 years now and place him side by side with you, and you are looking like as if you are age mates. You see? So those cases exist, but the law is clear there as to what must show otherwise. So the evidence to prove that this individual is capable of doing the others is sufficient. Now let's look at this one before we begin to wind down. Judicial officers. Judicial officers are not criminally responsible for anything done or omitted to be done by them in exercise of their judicial function, even though the act is done in excess of authority or is bound to do what he omitted to do. Now, in all of these, there are privileges that people enjoy by virtue of their office. There are some things now, if I want to speak outside the class, I cannot say, right? But I can freely talk to them, speak to them, or use them to teach you because I'm in the classroom. And then I will not have any form of liability. The same thing applies to officers. There are a lot of things that are incidental to the offices that we occupy. There are some things that a police officer will do that doing it is incidental to his power, not that he has power to do so. I'm trying to break in an example of what we're talking about. Okay, let's say that even when the police officer wants to make an arrest, there's still need for him to do it in the way that the law has prescribed. Can a single police officer successfully arrest 5 people without either making them to be in a situation where they cannot overpower him? Probably he's having a gun and he's asking all of them to lie down, either stay inside the water. These are extraordinary situations that if he does not engage that act, which is against the law, or which is something that he ought not to have done, but the circumstance at the time is necessitating it. So, but basically we are focused on judicial officers here, and the law will excuse them in that light. The other one is justification, excuse, and compulsion. This is another defense to criminal liability. A person is not criminally responsible for an act of omission if he does or omit to do any act under any of the following circumstances in the execution of a law. Now, a police officer is in chase of an alleged individual, and then suddenly the person that is chasing brought out a gun and started shooting at people. What is necessary for him to do at that point is what? To gun him down. That is, even if it will lead to the death of that person, it will be justifiable because of the circumstance in which we have. Because it could lead to more casualties by the act of the alleged offender if it's not stopped. Then, in obedience of the order of a competent authority, which is bound to obey, those who kill during firing squad, they are not in any way liable for killing. For killing is killing, right? But because they are carrying out a lawful order, they are covered by law. Yes, please. Yes.
I would say, according to number one, the definition of the law, and the police officer and under that. So the man is actually an offender,
Yes.
and it's the cost of getting in, the police officer shot at him, and that's eventually killed the man's son.
Sorry. You see, traffic offense is a minor offense, which even if it is allowed to escape, the state will not lose anything than killing somebody. Killing, the state will lose. But if it's made to, that's why the law will even allow 99 guilty people to walk free than an innocent person to be punished. So that's it. Yes.
Scenarios.
Yeah.
The guy might walk away. Reason being that
Yeah.
the team doing the traffic work
Yeah.
was different from the team that fired.
Okay.
The team that fired
Yeah.
just to be punished from the
Okay.
they now saw what happened.
Okay. And intervene. Irrespective of that, the situation on ground will also determine. Like when we'll be talking about self-defense now, we're talking about commensurate action. Let's even say they were pursuing him and death results, it will even still be a more acceptable thing than shooting at him in a crowded place. That's another view to it. So, when the act is reasonably necessary in order to resist actual or lawful violence threatened by him or to another person in his presence. I said that earlier. If it's just shooting, making an attempt to kill, and then it's brought down, then you are not liable. When he does or mean to do anything to save himself from immediate death or grievous harm threatening to be inflicted upon him by some person actually present and in a position to execute the threat, and believing himself to be unable otherwise to escape carrying out of the threat into execution. Now, this is similar to self-defense, but self-defense comes with conditions, which makes it very difficult to engage at all times. And that's why those who may even make attempt to claim self-defense don't usually succeed because of those conditions that are attached to it. Okay? Okay, so we'll do this, which is the last defense we're going to look at. Self-defense. No responsibility for an offense committed in self-defense. If you are defending yourself, no liability for it. But this is where there is liability. The limitations are these. The harm threatened must be death or grievous bodily harm. How do we define or identify grievous bodily harm? Or we start by identifying what can cause grievous bodily harm. If someone wants to use maybe this charger, wants to use this charger to hit you, and then you carry a gun and shoot at the person, and you say it's self-defense, what death or what bodily harm can this cause? The law will be interested in looking and putting everything on the table. So it's not a matter of the self-defense. Don't let anybody deceive you that you want to deceive, you want to defend yourself. Then number two, it must be immediate such that the person threatened does not have the time to seek help from appropriate authorities in a condition where it is either you kill that person or you die. It's not that, okay, say for example now, The assailant is there. He's holding a 2x2. This door is open. That place is open. And you are here. And he's there. And then you now wait for him to come. As he's approaching you, you just shoot it. That defense will not avail you. You know why? What? There's an opportunity for you to escape. So not taking that opportunity, if you run out, you can even shout and the security will come. So the law is wise in several ways, of course, because it's also human being that is making them. Otherwise, many people will hide under this and finish their enemies. Number 3, it must be inflicted upon the person threatened and not somebody close to him. If the intention is to harm the person directly, even though we have seen in some other section where the law may also expect you to take some steps to defend others, but all these conditions are very strict in application. Then the threat is made by somebody present and actually in a position to carry out the threat. No defense if it is carried out by phone or letter. Why is it so? If a letter was sent to you or sent to the person, because already there is an avenue for the person to run to the authority that, see me, I got this letter. And there's even a way of escape. You can go to your village and go and hide there. If you don't do any of that, and then the person is not present, you now send your own people to go and kill him. Say you are self-defense. It will not work. The person, yes, please.
You get a scenario of if something happened and there's a way of it.
Yes.
What if you're trying to escape and the person kills the person?
But then you must engage that way of escape.
So you are not allowed to defend it.
The person will not be alive to do that. But the law also makes it like a form of prevention. But again, the circumstance of the case will determine. If I said the person is holding 2x2, not the gun, there's no way we, except maybe the person, if the person is crippled, okay, if the person is crippled or the person is sick or the person is handicapped that he cannot move, that's an exception. Even if he throws the thing at you, you can still dodge it or deflect it. Not now waiting as he's making the effort. So the person threatened must believe that there is no way of escaping the threat against him other than by committing the act in question. The doors are shut. He has a gun. Unfortunately, the kind of burglary proof in this place, and you have a gun, and he has pulled the trigger, you missed it by chance. The best thing for you is to fire at him. Yes. What? Yes, it can still come under that defense because 2x2 can kill. More so that there is no way of escape. Do you understand? So it does not apply to crime punishable with death or in which grievous bodily harm or intention to cause such harm is an element. the law will also look at your intention. You know, there are some people they'll be waiting for their enemy. The day he will do something small, they do what is in their mind. You know what is in their mind is an intention. It's something that has been premeditated. Just waiting for the appropriate day to strike. So with this, we come to the end of the class on defenses to criminal liability. Thank you.